starting presumption is that it's going to be divided equally. It's a pretty blanket statement. So it's real crucial that it's kept truly separate. But that the court could look at that and say, well, they're getting $1 million inheritance. If it's filed as a sworn statement, you're perjuring yourself.
Well, hello and welcome to the Wisconsin Family Law Insider. My name is Jeff Hughes and I'm the CEO of Sterling Lawyers. I'm your co-host and I have with me Holly Mullin today. Holly is our managing partner. She oversees our entire legal team and paralegals and lawyers. In this video, Holly walks through how Wisconsin judges analyze and rule on property and debt division. So welcome, Holly.
Thank you, Jeff, and thank you for having me.
You know, one of the big issues that is present in divorce, and every divorce pretty much has this issue, and that's the issue of property and debt division. It can be really confusing to understand how it works in our Wisconsin courts. So let's start off by talking about how our lawmakers look at property division at the time of divorce, and then kind of walk through, if you could, the whole process to help someone get a high overview of how it works.
Sure. So Wisconsin is in the minority of states, frankly, in how we look at property at the time of a divorce. So we are a marital property state. Others call it community property state. But bottom line is that we treat all assets at the time of the divorce equally, meaning whatever's in the pot, the marital pot, whatever you have at the time of divorce is going to be divided, and the starting presumption is that it's going to be divided equally. So I think we're one of 9 or 10 states that
Sounds
view
right.
property this way. It's a pretty blanket statement in our statutes that describe, hey, at the time of divorce, all assets that were brought into or accumulated during the marriage are considered marital assets subject to equal division, with the exception of basically 2 things, and that is assets that were gifted to a party or assets that were inherited by a party. So again, that's assets brought into, meaning you had them before the marriage or you accumulated them during the marriage. So if that isn't something that you are wanting to sign on to, prenup is how you prevent that. But I mean, without a prenup, you are signing on to that law.
Yeah. You said something, or you kind of cracked the door a little bit on this absolute blanket 50-50 division, where you said it's a starting presumption. Could you unpack that, what that means and how that could be overcome?
Yep. So 2 exceptions that are really clearly spelled out are gifts and inheritance. So if a party, either before the marriage or during, is gifted or inherited, like they have assets that are gifted to them, not to the marriage, right? Not like a check during the holidays written to both parties from, husband's mother. It's like, well, that's a marital gift. But if it's a gift from a third party to just one person of the marriage, say husband gets a $20,000 check at the holidays, and that money is kept separate, meaning it's not put into a joint checking or a joint savings or any other account that's mixed with other marital assets, but it's kept totally separate, that will be excluded from the marital estate that will be subject to division. But that's a really crucial element of this, is the maintaining a totally separate identity. So that's true for gifts or inheritance. If it is deposited and kept separate, it will not be divisible. But it's up to the person alleging the separate property to prove that. So if I'm saying, look, I received an inheritance from a life insurance policy and I kept it separate, I have to prove I got that life insurance and this is where I deposited it and it never got mixed with other money. That's up to me. I have the burden of showing that to a court, that it is truly a gift or inheritance and it never got mixed with other marital assets or marital income, right? If I have one paycheck drop into that account, that paycheck is marital. The word is commingled, right? You just mixed it with other marital assets and you can't unmix it. So it's real crucial that it's kept truly separate.
Now, you can imagine, I'm sure you've seen this, there can be really unfair applications of this law. So throw a hypothetical at you, and how would you handle this? let's say spouse one comes into the marriage with $1 million worth of assets that they accumulated over years of working and saving very diligently. They marry someone who doesn't have anything financially when they come into the marriage. They're married for 2 years, and whoops, that was a big mistake. They go get a divorce. Is there a fairness component that the judge can look at and say, that really wouldn't be fair to just divide it up 50-50? Or is that just the judge's hands are tied?
So, as I said, starting presumption, equal division. The court may deviate from an equal division after certain considerations. And so,
Okay.
yes, one of those considerations is property, like assets or debts that was brought into the marriage by one party versus the other, right? Like
Mhm.
that can be a consideration. Um, I would tell you in a shorter term marriage, courts are likely, again, it's not a mandate. It is very much a judge's discretionary, I mean, it's their decision to make
Mhm.
is how far they want to look back. But if you're like your example of a 2-year marriage and a very substantial differential of assets, I
Mhm.
think it's fairly likely a court is going to look back and may not give the person a dollar for dollar offset on what they brought in,
Mhm.
but likely to do something unequal, deviate from that unequal division based on the fact that that one person brought in substantially more assets.
Yeah.
But again, it's a consideration. It's not a mandate. So you
Mhm.
do put yourself at a pretty good amount of risk um, if you're hanging your hat on that.
Yeah.
You don't
Yeah.
have any absolute protection on that when you bring something in. So that's again one consideration
Mhm.
is just that time of like at the time of marriage, who brought in what.
Yeah. Are there other considerations the courts can look at? The judges can say, okay, based on these other factors, I'm going to deviate from that presumption of 50-50 split.
Yes, it would be contributions to the household of
Mhm.
one party. So, like for example, you might find that one spouse had a significant contribution to the child rearing.
Mhm.
They didn't work, so they didn't really accumulate a 401k, but they were at home cooking and cleaning. So that was like their full-time job and they were schlepping the kids around to all the activities and
Yeah.
the other parent could be at work late and they never had to pay for a daycare provider. That is a contribution that can't be really viewed as like a monetary asset, but it is real contribution and the court will recognize it as such, right? Like
Mhm.
that's one of those um, considerations. The court actually can consider what I was just saying, the gifts and inheritance.
Mhm.
So let's say there is a really substantial gift or inheritance that only one party is going to get. The court could actually, they can't divide that gift or inheritance because it's excluded, but that the court could look at that and say, well, they're getting $1 million inheritance. I could choose to deviate from a 50-50 division based on the fact that one party is getting so much non-marital asset.
Mhm.
So it's
Yeah.
kind of a funny double-edged sword there. It's like they can't divide the gift or inheritance directly, but they could divide the marital property in an unequal fashion because of it.
Yeah. So, whenever the parties file, how do they know what assets are there and what debt is there?
So during a divorce proceeding, each party is required by law to complete something called a financial disclosure statement. So,
Mhm.
financial disclosure statement is signed by the party who's completing it, swearing that it's a full disclosure of their income, assets, debts, liabilities. So, it's going to disclose everything from what are they earning, what do they own, what do they owe, and it's intended to create a comprehensive picture of the marital estate, what's out there. Because everything that's put on that financial disclosure should be addressed at the time of divorce, meaning
Yeah.
if there's assets listed, who's getting that asset or how is that asset being divided. So that is intended to be a disclosure, not just to the court, but to the other party, so that
Mhm.
everyone is making informed choices during
Mhm.
the process.
Yeah. So, would you also have to include on there inherited assets if you know they're
Yep.
going to be excluded? So everything goes on there. Don't leave it off, right?
there's even a section that says, assets acquired by gift or inheritance. There's in some forms, not all of them, they'll even be like assets brought into the marriage. So
Yeah.
like premarital assets that you have. Yep.
And this is a affidavit signed under oath under penalty of perjury if you misrepresent.
It's not technically an affidavit because there's no notary on it, but there is a phrase at the bottom that says that you swear that the contents of this document are true and correct to the best of your knowledge, and it gets filed with a court. And uh, if it's filed as a sworn statement, you're perjuring yourself if it's not accurate.
Yeah.
And if, I mean, let's say you choose not to, or you forget of, the $2,000 in the suitcase under the bed, you don't disclose it. I mean,
Go
if that
bag.
becomes, yeah, if that becomes discovered, number one, that can be a contempt action against you. The
Yeah.
court isn't going to have a whole lot of sympathy for a person who unreasonably failed to disclose an asset. And oftentimes, judgments of divorce will say in the event somebody failed to disclose this, it can reopen the judgment of divorce. So it's
Yeah.
like,
Pretty severe
I
consequences.
it is. It's very
And
severe.
you totally wreck your credibility with the judge too. If you're hiding
Yeah.
assets, if you want to have any favorable decisions in the rest of your case, you're basically shooting yourself in the foot by lying and failing to disclose something.
Spot on. Totally agree.
So when parties agree that they have an asset, but they don't agree on the value, they can go get it appraised. So the common one would be like your house or a pension or something like that. But you can also get personal property appraised. You can get just about anything appraised, from an obscure art collection to a watch collection or whatever. That there's all stuff that can be appraised, right?
Yeah. Yeah, and as you said, the most common one is the real estate, but those are probably present in almost 50% of divorces. I would say that we're having
Mm-hmm.
one or more properties appraised. The personal property stuff, that becomes more rare just because of the cost. I
Mm-hmm.
mean, you don't see a lot of personal appraisal options out there, period. And then those that you can find are very expensive. So, for the juice to be worth the squeeze, so to speak, like it better be a worthwhile endeavor. Like, are you really going to spend $3,000 to appraise, a watch collection that's worth $2,000? Like,
Yeah.
you want to make sure it's worth your while to actually undergo that. Because it's putsy work for
Yeah.
so think like doing a whole like a house full of personal property and furniture. It's like your used couch is not worth as much as you think it is.
So ultimately, after the parties have negotiated, if they're unable to reach an agreement on how property and debt is to be divided, what is the final recourse that happens in that case?
So a judge will decide for you, and that's the truth with basically everything in a divorce. Is we hope that the parties and their attorneys can work together to reach an agreement, but if they can't, we're going to just bring our arguments to a judge and they're going to decide for you. Again, it's a pretty expensive endeavor to let a judge make that decision for you, but
Mhm.
um, that's the outcome. That's how you get resolution if you absolutely cannot reach an agreement, is the judge will decide on your property and debt division.
Yeah. Well, thank you, Holly. That's been tremendous. You've walked us through how this works in Wisconsin, how property and debt is divided. Appreciate your thoroughness and simple explanation for how it all works.
Thank you so much, Jeff.